Mr. Zhulkarnain, Abdul Rahim.
Mr. Deputy Speaker, this bill will introduce the enhanced maintenance enforcement process to facilitate maintenance outcomes for parties and will put our judiciary in a good position to strengthen and mete out therapeutic justice in the divorce process. In my law practice, I handle some matrimonial cases on a pro bono basis. One such case was when I was assigned by the Legal Aid Bureau to represent a young mother of 4 in a divorce proceeding. That case shaped my thinking on how we can and should make it easier for estranged spouses to claim maintenance for their children when divorce occurs. Please allow me to share her story. Madam Wati, not her real name, was only 19 years old when she got married, and as such, she was not named as a joint owner of the HDB flat that she lived with her husband because she was not yet 21 years old. Unfortunately, she was in an abusive marriage, suffering under the hands of an abusive husband she once loved. She was a housewife with no other sources of income and wholly dependent on the sole breadwinner. She endured the strain of the relationship and the pain of abuse and held on because of her young children. She would have had a 5th child if not for a miscarriage that she suffered after a beating so bad that she was hospitalized for a week. The doctors had to perform a hysterectomy, and she can never have another child ever again. Finally, she mustered enough courage to seek divorce. However, she was faced back then with a process that was cumbersome and daunting for a single mother to navigate. The ex-spouse had sought to kick her and the children out of the matrimonial flat because she was not listed as an owner and refused to agree to any division of assets in her favor. She finally sought help from the Legal Aid Bureau. She had to go to family court, as it then was, to seek enforcement and variation of maintenance orders to feed her children, and at the same time sought out her divorce proceedings before the Sharia court, a court case that was protracted by the ex-spouse all the way to the appellate stage. I recall the maintenance order, which I found out of the ordinary. Typically, such orders would set out the amount to be paid for each child or spouse and the bank account details for such sums to be deposited. However, this one had not only the usual quantum and details, but it also specified exactly what items that this ex-spouse had to purchase for the children. Things like baby formula milk, diapers, and even to specify the type of necessities, basic stuff like food and educational expenses. What kind of parent must be told and compelled to purchase sustenance for his own children? The ex-spouse had not only protracted proceedings, but also taken such acrimonious and unreasonable positions which necessitated such specific orders. Eventually, the appellate court held that she had a share and interest in the flat, notwithstanding that she was not listed as an owner. She also received settlement of the outstanding maintenance owed from the ex-spouse, but this was not before and during a lengthy court process. Throughout her ordeal, she almost gave up. She told me that she was fortunate to receive legal aid. Others may not have such fortunate ending. Madam Wati's case highlighted to me the need for us to facilitate the maintenance enforcement process for any parent, whether man or woman, to seek what is rightfully their children's and to alleviate some of the burden that they carry after divorce. It is in this spirit that I stand fully in support of the bill. I also welcome the protection of family violence survivors through limited cross-examination in certain circumstances. As raised in previous parliamentary speeches, I hope that there can be default video conferencing facilities within the FJC for young survivors to give evidence. This is to insulate them from further trauma on the stand. I understand that such infrastructure is already part of MinLaw's plans, and I look forward to the implementation in this regard. I have the following further clarification and suggestions. Firstly, on maintenance enforcement officers, I hope to hear more the plans on recruitment, resourcing, and training of such MEOs, especially given the caseload on the courts and enforcement of not just FJC court orders, but also Sharia court orders as well. Further, as MEOs encounter members of the public and to a certain degree may face hostile respondents or uncooperative third parties, may I ask, what are the protection and immunity that will be afforded to MEOs? Secondly, can the Ministry consider having all such maintenance orders reflected on a searchable database registry that can be accessed on a need-to-know basis by financial institutions or public agencies? This is to allow would-be public service employers and banks to conduct due diligence for checks on background or creditworthiness. Thirdly, on claiming for past outstanding maintenance, one clarification I have received is whether there is a time limitation period to make such claims under the MEP. Typically, as in the story I shared earlier, the victim would have had to endure many years of unpaid maintenance through protracted proceedings, and so not everyone would make a claim immediately upon breach. Fourthly, in some cases, there are other competing creditors. The usual refrain from ex-spouse is that he or she had to pay off other loans or financial commitments first. The financial strain on the paying party is real. We need to balance their interests too. This is especially in cases where the respondent has been declared bankrupt. In most cases, the applicant is unlikely to be able to recover any monies from an insolvent respondent. Hence, in this situation, what are the additional support that can be rendered to both parties? I understand that the reforms do not change the order of priorities of an insolvent debtor. In bankruptcy proceedings, if there had been unfair preference or transactions at undervalue, those assets can be clawed back. Hence, I look forward to understanding how the proposed MEP and the current bankruptcy regime will work together. Lastly, what are the steps that Ministry of Law, together with MSF, will take to raise awareness of the MEP and render assistance to laypersons who do not know how to navigate the claims and applications? I also hope that the MEP will also apply equally for the enforcement of Sharia court orders, especially on maintenance-like orders on payment of nafkah iddah and muta'ah. In Malay, please, sir. Pemindaan undang-undang ini akan menolong pemohon seperti bekas isteri atau suami mendapat nafkah yang tertunggak dengan lebih cepat dan membenarkan mahkamah melalui pegawai dan pejabat khas seperti MEO untuk mendapatkan maklumat terkini tentang status kewangan dan pendapatan oleh pihak-pihak yang tertentu. Ini adalah perubahan yang dialu-alukan. Dahulunya, seperti yang telah saya ceritakan tentang Puan Wati, bukan nama sebenarnya, proses mendapatkan nafkah hak anak bukan sahaja memakan masa yang panjang, tetapi boleh membebankan minda dan mematahkan semangat seseorang. Sebaiknya, apabila jodoh sudah berakhir, seharusnya pasangan berpisah secara damai. Kerana walaupun tiada lagi hubungan rumah tangga, namun jalinan kekeluargaan dan kasih sayang antara ibu bapa dengan anak-anak tidak harusnya terputus. Saya mengharapkan dengan adanya proses yang baharu ini, kita dapat memastikan bahawa hak nafkah anak-anak dapat diperuntukkan dengan secepat mungkin dan tanggungjawab memberi nafkah sebagai seorang ayah atau seorang ibu dapat dijalankan. Sir, notwithstanding my clarifications and suggestions, I stand fully in support of the bills.